Thank you very much for letting me speak to you today. In terms of teaching lawyers about arbitration law and arbitration procedure in the Asia Pacific region, I've been very lucky to have taught for the Chartered Institute of Arbitrators, the Singapore International Arbitration Centre, the ICC Court for Arbitration, and Young ICA. And I've conducted training across the Asian region, including being lucky enough to have even gone to the Maldives, to Sri Lanka, to Vietnam, Malaysia, China, Hong Kong, Australia, and of course Singapore, and met lots of wonderful young and not so young practitioners across the region through doing that. And in terms of how that's influenced my arbitral practice, I'd say there's a couple of things that I've learnt from teaching. First of all, it's a great refresher on the theory. The wonderful thing about students or people who are fairly new to arbitration is that they don't come in with sort of preconceptions. They don't start with the same assumptions as those of us who've been doing it for a long time. And so they tend to ask questions, well, why is it like that? And you're curious about things. And so that really means that you need to keep yourself up to date, look back over the New York Convention, look back over the Unstral Model Law and refresh your memory as to how those instruments work, how they work together, how the legislation in different countries work. And so it's a great refresher on the theory and really challenges you also too in terms of the practical things. Well, why do we do it this way? And is there a better way of doing it? So that's the first lesson that I take from teaching. The second lesson is that having taught in so many different jurisdictions in the Asia Pacific region, and also even for those courses in Hong Kong, Malaysia, and Singapore and Australia, there's often students from all over the Asia Pacific. So you get exposure to a lot of practitioners who often have been practicing in their local jurisdiction and are fairly new to international arbitration. And it's really fascinating to me to be able to sit down with them and to learn about how litigation and arbitration domestically is practiced in their country. And so you really learn a lot about the sort of different legal norms in jurisdictions within the Asia Pacific. And so I've really enjoyed that aspect of teaching, and obviously getting to know the students personally. Well, not only because of the pandemic, but even before the pandemic, we've seen the adoption of various tools in arbitration proceedings, and I suspect that these will become adopted more widely through the coming years. So as well as obviously using Zoom like we are today for answering these questions, for hearings, so as well as actually having virtual hearings, there's been a lot of other tech tools that have really come to the fore. There's, I think, for practitioners have used tools for discovery and disclosure processes, especially in very big disclosure exercises, for quite a number of years. So there are platforms like Relativity, for example, and Nuix, which have been used in order to review documents en masse, be able to tag them, identify them, produce them, etc., in both litigation and arbitration. And they are most definitely here to stay. I mean, one of the things about our electronic world is it just means that there is so many documents which need to be reviewed for any sort of disclosure exercise. So that's one tool. The other tool which is coming more to the fore is the technology used to make virtual electronic bundles for hearings. And I think we've seen this adopted a little bit during the pandemic. And I think it's also extremely useful in physical hearings as well. So this is when there's an electronic bundle using special software, which means that during the hearing itself, there'll be an operator who'll call up the document, and the document will be visible to the tribunal, visible to the counsel, and visible to the witness. You can put documents side by side so they're visible at the same time. With some software, you can actually highlight paragraphs and pull them out to allow the tribunal and the counsel and the witness to really zone in on a particular part of the document. And this technology, I think, is extremely useful in a hearing and saves a lot of time, and it really increases the efficiency. So rather than having the tribunal and counsel saying, oh, what document is that? And you open up your folder and you go through the index of the folder and try and find the document. Instead, we all can look at the same document together and know that we're looking at the same document together. That document become electronically marked in the transcript. And for tribunals who are becoming much more sophisticated about annotating documents electronically, they can have their own bundle with all the documents that have been referred to in the hearing with their own annotations. And so I think that there's some very, very useful tools there. The third one I'd like to mention, which I don't think has been as readily adopted yet, but I suspect is going to become more adopted in the future, is that of an electronic registry. So the Stockholm Chamber of Commerce Arbitration Institution was really ahead of the game here, in that they've adopted a sort of an electronic register of which allows for both all of the documents filed in the arbitration to be filed in a very sort of secure way by the parties. It's kept securely, sort of in a cloud system. The communications from the tribunal to the counsel is also all kept in that system, as well as the communications from the institution. And obviously there's sections which only the tribunal can access, and I think you can set up sections for only the counsel to access, but everything's there in a very secure, encrypted way. And it just means that it's not so difficult to track down those communications between tribunal and counsel, which, you know, it's all already there, and it can work also with the electronic bundling sort of software. So I think that we will see other institutions adopt similar tools, and obviously they're going to get more sophisticated. And I think that's fantastic, because obviously a lot of independent arbitrators, you know, they don't have big law firms supporting them. And even though I sit a lot as arbitrator, I still struggle with, you get sent documents all on different systems. You've got to set up yet another account in order to download those documents. I normally have to say to the parties, can you please include my personal assistant and send her a link as well to those documents so she can download them for me and save them. And it's actually quite time consuming. So the idea that I could log into an electronic registry and they all be there uploaded by the counsel themselves, rather than my personal assistant having to do it, and knowing that it's all secure and it's safe electronically, I think that's a fantastic development, and I'm really hopeful that more institutions go that way. Definitely. I mean, myself and I know others had already had experience with remote cross-examination even before the pandemic. I've been involved in a number of arbitrations, both as arbitrator and counsel, where due to cost reasons and also due to the fact that not a long examination was required and the witness was overseas, where we'd had witnesses cross-examined using video conference technology. The fantastic thing is that because of the pandemic, we've all become much more comfortable with that technology. That technology has improved. And so I suspect that we will see a lot of hybrid hearings in the future in which the less important witnesses are not required to fly halfway around the world. And this will be so much better for the planet, as well as obviously for the pocketbooks of the parties, and instead give their evidence remotely over the Zoom or Blue Jeans or the other technology used, or the old-fashioned video conference type facility that we used to use. So I think that this is going to certainly be something that will continue. In terms of hearings themselves being conducted completely virtually, as we've had over the last 2 years, and as continue for some hearings, I think there's a degree of flexibility there in terms of how tribunals think about these things now, given that it's still very difficult for people to travel from some countries in the region. So obviously in Asia Pacific, it's still extremely difficult for people from China and Hong Kong to travel for hearings. And so I expect that for those reasons, hearings will continue to either be conducted virtually or be a hybrid, with some participants participating in person and some participants participating virtually. And then again, for the benefit of the planet and also for cost reasons, I expect that we will see that a lot of procedural hearings will take place virtually as a matter of course from now on. In many cases, procedural hearings were taking place by teleconference prior to the pandemic. Now everyone's comfortable and used to video conference. I'm sure they will now all be conducted by video conference. There's a real virtue to actually being able to see people's faces in that respect. And I think even the larger procedural hearings that may once have been conducted in person will tend now to be conducted virtually. I expect you'll also see that some hearings where it's only legal submissions, such as jurisdiction hearings, may well be conducted virtually going forward, rather than the parties incurring the expense of getting everyone together. That said, while virtual hearings have worked pretty well, there are some downsides. For me, you lose some of the magic of a hearing. There's always something quite incredible that happens at a hearing. There's not always something that you don't expect to happen at a hearing. For the tribunal, it's so much easier to conduct deliberations together as a tribunal of 3 persons if you're all together in the same room, if you're all able to have morning tea together or lunch together or dinner together and talk after the day's hearings ended, and really, sort of explore the issues that you've heard. So I think there's real benefits to the tribunal of being able to sit together physically in person and have a hearing that way. I also think there's real benefit to the parties. And I think something that hasn't been talked about much, there's been a lot of talk about, is it possible to cross-examine witnesses virtually, etc. Yes, I think it is. I think some witnesses probably perform a little bit better in a physical setting. Some probably perform a bit better in a virtual setting. Yes, it's certainly possible to cross-examine witnesses in a virtual setting. But what has been lost is that at a physical hearing, you will normally have party representatives attend, not just the counsel for each party. And having the party representatives attend means that there's more opportunities for settlement, because they actually get to chat to each other over the coffee table, or, you know, the water cooler, as you might, in the US, they might refer to it. And so there's some opportunities to sort of break the barriers that may have occurred given the dispute. And there's an opportunity for people to have a conversation about settlement, which at the moment is not happening. And so I think there are some real advantages in being able to bring everyone together, although it is expensive, but being able to bring everyone together for the actual physical hearing does, to my mind, have some real advantages. So I'm sure that we'll start to see physical hearings starting up again for the main hearing once we can all travel. I spend a lot of time with my corporate colleagues, helping them with complex agreements, with drafting the dispute resolution provisions and reviewing the dispute resolution provisions in contracts. And obviously I see a lot of dispute resolution provisions when things go wrong. Now, the first piece of advice I would give is, especially for simple, straightforward contracts, use a model clause. All of the institutions have model clauses and they work. Okay, they cover all of the bases and they have all of the things you need in them. So use model clauses. So that's the first tip I would do. Second tip is, once you get a bit more sophisticated about drafting dispute resolution clauses, is that you need to think carefully about the choices you're making. And one of the things about arbitration clauses, which makes them much more difficult to draft than, say, a jurisdiction clause, is there's actually a number of choices. So for starters, there's the choice of the governing law for the contract itself. And that governing law does not have to match up with the seat of the arbitration. So you can have an arbitration seated in Singapore and the governing law of the contract is England and Wales. So you have to choose your governing law. You then have to choose your seat of arbitration. You have to choose whether or not you're going to have an ad hoc arbitration or an institutional arbitration. I think in this day and age, and particularly when you've got parties that come from different cultural backgrounds, it's actually helpful to have an institution. For domestic arbitration, I think ad hoc arbitration works fine, which is when you don't have an institution administrating it. But when you've got the possibility of things going wrong, I think it's better to have an institution involved. So you've got to choose your institution. You've got to decide whether or not you're going to have the UNCITRAL arbitration rules or the institutional rules. And then finally, you've got some matters which are often covered by institutional rules, but it can be helpful to include, like how many arbitrators you're going to have. Is it 1 or 3? Specifying the language of the arbitration proceedings. I would always recommend that you go for 1 language, not 2, because if you have 2 official languages for the arbitration proceedings, you end up having to translate everything. Whereas if you have 1 official language, you only have to translate, say, half of the documents. And also you should specify the law governing the arbitration agreement itself. So this is the law which determines whether or not the arbitration agreement is valid and how the arbitration agreement will be interpreted. And this is something that has really come to the fore because of a number of decisions where the arbitration clause may not have been valid at the seat under the law applicable at the seat, or may not have been valid under the governing law of the contract. And so it then becomes an issue as to which law determines the validity of the arbitration clause. So that's also another thing that's very important to include. The third thing I'd say about arbitration clauses is that there are a number of jurisdictions which are difficult when it comes to enforcement. And it's particularly in the Asia Pacific, there are some tricky jurisdictions. And so you want to run the arbitration clause past local council in those jurisdictions where you think you might need to enforce an arbitration award, and if you know that they're tricky. So there's certain requirements, for instance, to ensure that an arbitration clause is valid in China. Now, at the moment, they're looking at changing the arbitration law, so that may change in the future. It may be a little bit easier. But previously, you always had to ensure there was an arbitration institution administering an arbitration where the award was going to be enforced in China. So these sorts of nuances, it's very important to either check with an experienced arbitration practitioner who knows the region well, or to get local counsel involved to have a look at the arbitration clause in order to ensure that's enforceable. And the final tip that I mentioned is that actually to draft a complex arbitration clause, you really have to understand the theory of arbitration and how arbitration works theoretically in terms of the interaction between the New York Convention and the arbitration law in the jurisdiction of the seat, and then the arbitration laws in the countries where you might want to enforce. And so for that reason, I always suggest to younger practitioners that it is worth doing some of the courses offered by, the Chartered Institute of Arbitrators, or by some of the arbitral institutions or some of the universities, so that you get to understand that theoretical background and how it all works together, and the reason why you draft clauses the way you do. Thank you. I think diversity is important for three key reasons. First of all, it's really good for a tribunal particularly when a tribunal of three, to have members of the tribunal who have diverse views. This means that you end up with less groupthink on the tribunal, and so therefore it improves the quality of the decision making. It also helps to minimize any sort of unconscious bias that tribunal members may bring to hearing witnesses from, who may be from different backgrounds from their own. So I think it's really helpful to have a tribunal of different cultural backgrounds in terms of, understanding how, people from certain cultures may feel less comfortable with direct eye contact, for example. So I think it's really helpful to have a tribunal that is diverse and is able to understand the perspectives of both parties. Second key issue is, I think that parties like to have a tribunal that often contains a practitioner that they feel understands the cultural and legal background from which that party comes. Doesn't necessarily mean that every American company will appoint an American on the tribunal, or that every Vietnamese party will appoint a Vietnamese arbitrator on the tribunal. But I do think that parties feel, comfortable knowing that there's someone they've appointed on the tribunal who they think sort of gets where they're coming from. And certainly, I've done a number of disputes involving Vietnamese parties where I've been the presiding arbitrator, and there has been a Vietnamese arbitrator on the tribunal. And that's been extremely helpful when it's come to drafting communications to the parties, where that arbitrator has been able to say, look, I think this is where they're coming from. We should tweak the language in this way so that they'll understand it. and also that, you know, they can say, look, they may be thinking along these lines, because that's what's common in Vietnam. So let's make sure we cover off that issue. So it's certainly, I think it's extremely helpful. And I think the parties get a lot of comfort from having someone on the tribunal that they think understands where they're coming from. So that's the second key reason. The third key reason is, for instance, in terms of gender and making sure that we have in arbitration the most talented people. And the fact is that in many countries in the world, more than 50% of law graduates are now women. And so we need to make sure that arbitration is a career that is attractive to women lawyers, because otherwise we'll be missing out on a lot of talent. And we want to make sure that we have the most talented arbitrators and the most talented counsel. And so for that reason, I think that there's some organizations like the Pledge and Arbitral Women who've done a fantastic job in encouraging women within arbitration and ensuring that women are starting to get more appointments on panels. And I'm sure I've been a beneficiary of this to some extent. And now we're looking at too, well, how can we make sure that we're getting the talented arbitration counsel from Asia and from Africa, and making sure that they also have opportunities to be arbitrators and to appear in the biggest cases. And I think that's very much going to be the challenge for the future. And certainly that's something I'm really looking forward to, because one of the things I love about being arbitration counsel and being an arbitrator and being involved in the arbitration community is the fact that it's so diverse, and that you meet people from different parts of the world, and you get to work on cross-border disputes, and you get to know how things work in different parts of the world. And quite frankly, that's what makes it interesting and exciting for me. I think things have been improving. Over the last 10 years, I've noticed a big improvement in terms of the number of women, for example, being appointed as arbitrators. And that's probably the easiest sort of target to benchmark and to see whether or not panels are becoming more diverse. I do still think that there's a long way to go. When you look at the figures, you know, there's still a long way to go in terms of getting parties to appoint a broader range of arbitrators. I think there's always the fear as the party that you want to make sure that you can't be criticized for who you've chosen as an arbitrator, and so therefore choosing a really big name arbitrator is seen as the right way to go. In actual fact, I think there are lots of perhaps a little bit younger arbitrators who are really keen and work hard and come up with fantastic decisions and management of the procedures of arbitral proceedings. And I'm sure that those people are going to get even more appointments in the future, as I think, you know, parties are starting to be a little bit more willing to look beyond the standard choices. But that is a difficult thing for a big multinational to think about appointing people that they haven't appointed before. So there is always this sort of chicken and the egg thing. I think the institutions are doing a pretty good job at appointing a more diverse range of arbitrators. There's certainly been efforts made to give people their first appointments. I'm very grateful to the SAAC for being the institution that gave me my first appointment as an arbitrator, and you know, It's still giving me quite a number of appointments, which has led to me being able to, get the experience to get onto other panels and be appointed by other institutions and by parties directly themselves. So I think the institutions have a great role to play here, and in overall, I think are doing a pretty good job of it, but there's still a way to go.